Good evening, everyone. My name is Kathy, and I would like to welcome you all to the Harris Law Firm's webinar series, Wiser Together. Today's webinar, we will be discussing child support, getting more, paying less, and what the law says about it. And we are grateful you were all able to attend. As a member of the Colorado community for over 30 years, the Harris Law Firm has always tried to give back. This and future webinars are a free service we provide to that community. Now I'd like to introduce our presenter today, Katy Ellis. Katy Ellis is a partner at the Harris Law Firm. She has been practicing law since 2007. She clerked for the Colorado Court of Appeals before moving to private practice and has been focused primarily on family law since 2008. She is involved with the American Youth of Court, the Colorado Bar Association, and the Colorado Women's Bar Association. Katy practices as both a trial attorney and appellate attorney and has represented clients in appeals to the Colorado Court of Appeals and the Colorado Supreme Court. Now, I would like to turn it over to you, Katy.
Thanks, Kathy. So one piece of housekeeping of my own, which is a reminder that I give everyone at the beginning of any webinar that I'm helping to host here. And that is that the information we're providing in this series is designed to be informative and useful, but should not be considered specific legal advice for your matter. If you have questions about child support issues in your own life, in your own case, you should definitely consult with an attorney somewhere or a licensed legal paraprofessional to get some advice about how all of this plays out in your own life. One of the things you will hopefully take away from the webinar this evening is that every case is unique. There are a lot of factors that go into determining how child support will be calculated in any individual case. And there's just no way listening to a presentation like this, you could know what the right answer would be. I would also throw in with that general disclaimer that child support is one of the areas where I find people come in with a lot of preconceptions and ideas about how they think child support is going to work. Often the result of something that they either saw on TV or that they know anecdotally from what happened to their best friend or their relative. And it's amazing how often I get people who say, well, my best friend is getting this amount of child support. Is that what I'm going to get? And the answer is drastically different because their circumstances are different. So with all of that said, we will dig into some of this. Generally this evening, we're going to go over some of the basic concepts and fundamentals. So hopefully give you a better understanding of how child support works at all in the state of Colorado. We'll address some common scenarios. And we'll save some room for questions and answers at the end. I know that some of you submitted questions ahead of time, which Kathy has forwarded on to me. So I will address as many of those questions as I have time for at the end, but we'll also leave it open if any of you think of a question while we're going through the presentation, put those in the chat where Kathy said, and we'll get to those at the end as well if we have time. All right, so basic concepts. Colorado has a statute, the Colorado Revised Statute 1410-115, that deals explicitly with child support. This statute outlines how child support is calculated, how much will be owed, what counts as income, what factors the court has to consider. And child support in Colorado, at least, is special in the sense that it is one of the only places where we can kind of give you a predictable right answer to what's going to happen. There is a lot less discretion in the world of child support than there is in any of the other areas in a dissolution of marriage or parental responsibilities case. So issues regarding the parenting plan, right, where the kids are going to live, how much time they're going to spend with each parent, decision-making responsibility, spousal maintenance, or what we used to call alimony, the division of property. All of those are areas where there is a lot of discretion for the court when it's deciding what's best for the children. Child support, although still guided by that underlying idea of what's in the best interest of the children, has a fairly formulaic approach to give us an answer to what the child support should be. We'll spend some time tonight talking about what factors go into that, but generally speaking, this is an income shares model. This is something that Colorado, along with about 40 of the other US states, slightly more than that, follow. They're not all identical in terms of how they calculate support, but all of those states have the same basic idea that child support should be the result of a formula that compares the incomes of both parties. In other words, child support is not calculated solely based on the income of the parent who has less parenting time, right? It really does depend on how much each parent is earning, in addition to a bunch of other factors that we're going to cover. And as I've already alluded to, it is a formula approach, right? The idea is if you input data into the formula, you will get back the answer to the question, what should child support be? It is also a presumptive amount. That's where I was saying there's not that much discretion involved. If the child support worksheet comes back and says the amount owed is $1,200 a month or $200 a month, that is difficult to deviate from. There have to be good reasons to deviate, and those reasons have to be in the best interest of the child. So as we go through the rest of this little webinar tonight, I'll discuss some of the scenarios where deviation makes sense and where a court might say, even though the worksheet says 1,200, I'm going to set child support at 700, or I'm going to set it at 2,000, or whatever else might make sense in this case. All right, leeway for negotiations. So as I just said, it's pretty formulaic. The short answer is no, or there's not much leeway. But I should note that a formula is only as good as the data that goes into it, right? So when people are calculating child support, part of what matters is figuring out the right answer to questions like how much is each party's income? What are we counting as income? And then a bunch of other factors that, again, as we get to them, I'll give you some examples of ways that deviation may occur. It's also important to understand in the state of Colorado, we have very clear guidance from our appellate courts that child support is the right of the child or the children in a case. In other words, if the child support worksheet comes back and says one parent is supposed to be paying the other one $1,000 a month, courts are very reluctant to let parents just say, well, it says $1,000 a month, but we've decided we don't want to deal with child support, so we're just not going to have any. Generally not how it works. So instead, if the child support statute says $1,200 a month, it is very likely that's going to be the child support amount. And the court would deviate from that only if it really believed that the deviation was in the best interest of the children. To give you a couple examples of that, I had a case many years ago where the mother had kind of a long-term struggle with alcohol use. She had been sober for a very long time, had been doing a really wonderful job managing that. And then some events happened in her life that made that a challenge for her. She lost her sobriety and was in pretty bad shape for a while. After completing an inpatient rehabilitation process, when she got out, she and the dad agreed that their daughter, who was now living with him, they first of all agreed the daughter would live with him for the immediate future, while mom and daughter worked through some of the issues that arose when mom was having a hard time managing her alcohol use. When mom then got out of rehab, dad was actually wonderful in this case and wanted to support mom's ability to maintain sobriety, to get back on track, and to repair her relationship with her daughter. And both mom and dad recognized that if mom was also burdened with having to pay child support and work full time and do all of that, that it would pose a major setback to her ability to get on track. So they agreed to basically suspend any obligation to pay child support by mom for 6 months and give her that window of time to figure out what was going on and focus on her sobriety. They agreed that was in the child's best interest. Both because dad didn't need the financial support from mom and because in the long run, they truly believed mom would come out a better parent if she had that break from the weight of child support. So that's an example where it made sense and the court agreed that it was in the child's best interest, not just what was fair to the parents, to deviate. One of the things that factors into the child support calculation is parenting time. In Colorado, the magic language is overnights. All right, so the amount of time that the child or children spend with each parent affect the amount of child support is paid. The underlying logic of that is that if your kids are living with you half the time or 40% of the time, you're already paying certain expenses for them, right? Your home is probably slightly larger than it would be if you had no kids. Your electric bill is higher. Your food budget is probably higher, especially if you have young children that eat nothing but berries or teenagers that eat everything, right? So they're already assuming if the kids are living with you a significant amount of the time, that you're paying more for their upkeep in general already. You're already contributing to their support just by taking care of them in your home. So these overnights will impact the formula. And in order to get to how that all plays out, we're going to talk a little bit about how the parenting time itself is decided. Before we get there, I want to sort of stick a pin in this idea that it's overnights that count. We're going to talk a little bit more about what an overnight means, but that's another example of something where we might be willing to do some deviation, and I'll talk about that when we get there. So first and foremost, when we're deciding what the parenting time schedule will be, there are certain factors the court has to consider. We are not going to spend a lot of time on this because we have whole other presentations that deal with almost nothing but the best interest of the child standards that deal with parenting time issues. But in order to get some idea why this matters, we'll talk through what those factors are. One of them is what each parent wishes, right? What does each parent think is best for their kids as far as a parenting time schedule? Another is what the child's wishes are. If the child in question is sufficiently mature to make a reasoned and independent decision about what they think is best for themselves. And again, we have whole other webinars on parenting time, so I won't delve into that too deeply, but just know one of the most common questions I get asked on this issue is how old, at what age can my child decide for themselves what the parenting plan will be? In Colorado, the answer to that is when they are not a child. When they are 18 years old, they can decide if they're going to live with their parents or with someone else or which parent. But until that point, they don't actually get to decide. Their wishes can be considered, but there are a lot of very good reasons that we discuss in other webinars that we don't let our 13 and 14 and 15-year-olds just decide what they want. Or frankly, our 2-year-olds. All right, the court also has to consider the interaction and interrelationships the child has with the parents, but also other important people in their lives, siblings, step-siblings, grandparents, their babysitters, whoever it is that is an important figure in their life, the mental and physical health of the parties and the children, the history of parenting time and sort of the history of the family together. That does not mean that a parent who historically has had less parenting time can't become more involved when the parents are divorcing or separating from one another. But the history is relevant to figuring out, again, what's in the best interest of the child, because that's the standard we're dealing with. Proximity of the parents, right? The answer to the question, how much parenting time is each parent going to have, will hopefully obviously be different if the parents live 2 miles away from each other than if one of the parents lives in Colorado and one lives in Alaska. So practical realities about that proximity matter. And then also the ability of each parent to encourage the other parent's relationship with the child. That is something that matters. It's important to know, though, that although the amount of parenting time a parent has affects child support, they don't determine one another in the sense that you can't withhold parenting time if someone doesn't pay support. So if someone is supposed to be paying you child support and they're supposed to have parenting time this weekend, you do not get to tell them, because you didn't pay support this month, you don't get to see your child. That is not how that works. They are separate issues in terms of enforcement. So if someone is not paying their child support, there are methods to go after that financial support. But again, remembering that the best interest of the child underlies all of this, we don't want to interrupt a child's relationship with a parent just because they are not meeting their financial obligations. Similarly, you don't get to demand parenting time based on paying child support, right? So paying that child support is not like renting your child, right? You're not saying, I'll give you $500 if I can have 3 nights with them this week. That's not how it works. So again, if you are paying your support, if you're paying a lot of support, it doesn't guarantee that you're going to have parenting time or parenting time on the days you want or with the frequency that you want. Those are still separate questions. It's also important to understand that decision-making does not include the right to decide whether your child is going to see the other parent. Some parents get very confused about this. They think that because they have sole decision-making about certain issues or maybe about all the issues, that that means they can decide, hey, this weekend's not convenient. The kids aren't going to see you until next week. That is absolutely fundamentally untrue. All right, joint and sole decision-making have nothing to do with calculating parenting time, and having sole decision-making doesn't give you the right to interfere with someone else's parenting time. The factors do include the number of overnights, but nothing to do with custody or major decisions. And I'm going to take this moment because I don't remember where in these particular slides we get to the idea of overnights. So I do want to spend a second talking about that. There are cases where if we only base support on the idea of overnights, we would be making a big mistake. A good example of that was I had a very nice couple many years ago where the mom, it was a mom and a dad, and the mom in that case, this family, or this family relationship here, because these folks had never really lived together or been married. But mom and dad didn't have the financial luxury of either of them staying home for a significant amount of time after their child was born. So when they had their child, I think mom had to go back to work after about 3 weeks. As a parent myself, that feels impossible, and I cannot understand how she managed to do it, but she did. She went back to work full time. The dad was also working full time. Mom worked nights and dad worked days. And the only way this worked for their young child was that mom would get done with her shift in the morning. She would go pick the child up. She'd have the child all day. Dad would pick the kid up around 8 o'clock at night, before mom went to work her night shift. And so dad had technically every overnight, but pretending in that circumstance that dad was doing basically all of the parenting and that mom's contributions didn't warrant an adjustment to child support would have been grossly unfair and wrong. They had a newborn. I recognize newborns are also awake at night. It's strange how often their sleep schedule doesn't line up with ours. However, mom was definitely parenting at least as much as dad was. And that was another example of a case where we deviated and agreed to treat it as though they had equal overnights because they were definitely pulling equal weight in parenting the child. All right, so some of the nuts and bolts. Ironically, here's where the number of overnight slide is. So we only jumped the gun a little bit. It is a specific factor in the formula. Like I said, it there are ways to deviate from overnights, but generally speaking, it's the number of overnights in a household that's going to affect child support. There's a common misperception that every additional overnight lowers the amount of child support you have. Really what it is there's a threshold up to 25% of the time. So if one parent has 75% or more of the parenting time, then the amount of parenting time the other parent has does not matter. In other words, if in a year you have anywhere between 0 and 92 overnights, it does not matter how many. 75, 0, 10, 15, any of those numbers are going to generate the same amount of child support on the worksheet. But once you hit that magic threshold of 25%, which works out to 93 overnights, the amount of overnights you have with the child does start to affect parenting time. So someone who has 90 overnights with their kid or with their children every year is going to be paying more child support than someone with all other factors the same who has 93 overnights or who has 110, right? And the person with 110 is going to pay a different amount than the one who's only has 93. So a little bit to think about there. And like I said, it is proportional. So the more parenting time you have once you cross that threshold of 93 overnights, the more it will affect the child support. And again, the general idea is that the more time you have, the less support you're paying because we are assuming that you are already paying some child support elsewhere. All right, what is an overnight? It's the actual sleepover visit, right? The number of hours is irrelevant. We're not looking at, well, they spent 16 hours at one house and 8 at another. That's not the determination. It's really where the kids are sleeping. And like I've already said a couple of times now, that is one of those places where sometimes it does make sense to deviate or for the parties to get into trying to decide, does this count as an overnight, right? If we're exchanging at midnight, who gets credit for that? I don't know why you'd be exchanging at midnight. That seems cruel to everybody involved. Just throwing that out as an example. All right. Equal parenting time. So if the children are spending exactly half of their time at one parent's house and exactly half of their time at the other parent's house, does that mean there's no child support? Many people think it does. It does not. Okay. Parenting time is not the only part of child support. And like I said at the very beginning, Colorado is set up to be a formula based on respective income. So it is not just that the person with the most parenting time gets support from the other parent. It's not that simple. If you have a situation where the parents have exactly equal parenting time and one of them earns more than the other one does, there is probably going to be some child support from the higher earning parent to the lower earning parent. It's also important to note, though, that there are more things than just income that affect the worksheet. So other things that go on the worksheet are things like who's paying for the child's share of health insurance? Does the child have any extraordinary medical expenses like regular therapy appointments or ongoing medical treatment for a condition that they may have? If so, those things also get factored into the child support worksheet. So in a scenario where the parents have equal parenting time, and their incomes are the same. Let's say they each make exactly $70,000 a year. If one of them is paying health insurance for their child and the cost of health insurance for the child is $300 a month because they have very nice insurance through their employer, the other parent is going to end up paying them $150 a month as child support to balance out their half of the cost of that insurance. Okay, the cost of things like that end up being proportional. So if you don't have equal income, if one parent earns, let's say, 75% of the total income and the other parent earns 25% of the total income, the person who's paying insurance is going to reimburse the other one proportionate to that. So if the higher earning spouse in that scenario earns 75% of the total income and they're paying the health insurance, the amount of child support changing hands is going to adjust so that the lower earning spouse is contributing 25% of the health insurance. All right. Sometimes we have situations where there are more than one child and they don't have the same parenting time schedule. There are a lot of reasons this can happen. Again, we're not in a parenting time webinar tonight, so I won't go into all the details, but one of the most common situations is if you have a newborn and an older child. You may have a situation where one of the kids is 8, and that 8-year-old is perfectly capable of spending 50% of their time with each parent. They may love that, right? They may really love getting to spend half their time with each of their parents. But the newborn is still breastfeeding, is definitely in need of a different type of attachment. And so in that scenario, you may have a parenting plan where one parent has 50% of the overnights with the 8-year-old and no overnights with the youngest child, or only has one overnight a week with the younger child. The way that we calculate that in Colorado now is we do a percentage of overnights with each parent in order to figure out what's fair. So what we calculate is basically it used to be unclear in our statute. And so we had this case, marriage of qualm. The legislature liked that approach. So they've modified the statute. So it now does the same thing as what the qualm case did. And basically you come up with an average. So if one child spends 183 overnights a year with each 182 and a half, right, with each parent, and the other child spends none, then the average number of overnights works out to right about that magic 25% number, that 92 or 93 nights, right? You may also have a situation where the average number of nights for the two kids ends up being 40% instead of 50%. And that's what you would use in order to come up with the actual child support amount. All right. Changes. So the other thing that's really fun about family law cases is, and this should not be surprising to any of you with children, I'm assuming most of you have children or you wouldn't be on this call, kids change, their situation changes, what they need changes. Our lives change, right? So I'll give you a few examples of things that can change over time that would affect child support. One of the obvious ones is if the number of overnights changes. Right? If you're in the scenario I was just describing where one of the children at the time parents separate is a newborn, hopefully over time, that child is going to start spending more and more time with the other parent, with the non-primary parent in that instance. And eventually they'll get to a point where they start having overnights. And maybe they even work all the way up to having equal parenting time. Maybe they're on the same schedule as their 8-year-old, now older than that, sibling, right? So that's one thing that will affect child support. Another thing that would justify a change in child support is if your incomes substantially change. So if at the time a couple separates, one of the parents really isn't working, or they are only working minimum wage job, they're only working part-time, but after they've been out in the workforce for a while, they get a better job, they get more experience, now they're earning $70,000 or $80,000 a year. That might be a basis to modify the support. One of the parents may just radically shift jobs. Now they're done with school, right? They've finished school. They can actually be employed instead of just bleeding money to student loans. They're now earning money and they're capable of contributing differently to the support of the children. And the kids' expenses also matter. Among the things that factor pretty heavily into that child support calculation are those things like the cost of health insurance, the cost of extraordinary medical expenses, education. If the parents agree that they're going to enroll their child in a private school, if the child has ongoing tutoring or other educational costs that you want to factor into the worksheet. Another great example is childcare. If you have a little kid and you're spending what feels like and often is essentially another mortgage payment, keeping them alive while you're at work, that is something that can go into the worksheet. So any of those things can affect the worksheet and can justify a change in child support. One of the basic principles, though, is that with child support, the default assumption is that it can only modify from the time you file a motion forward. So if you know that your former partner just got a new job and they're making twice what they used to make, you should file your motion to modify. Run some calculations first, and I'll talk a little bit about how to do that. But if it looks like child support's going to change, file your motion as soon as possible. Because generally speaking, the court can only modify support back to the time you filed the motion. If you come to court in June and say, well, I know that back in January, my ex got a new job and now they're making $300,000 a year. Before they were making 70. Shouldn't that matter? Of course it matters. But the support is only going to modify from June when you filed your motion forward. The court cannot go backward. There is an exception, which is sitting right up here on the screen waiting for me, which says child support can be retroactive to the date of change. That is only if the parenting time has changed. So let's see if we can get this clear. Okay. So if the parents mutually agree to change the parenting plan, let's go back to my example with the newborn baby and the 8-year-old. If those parents are truly co-parenting well and thinking about the best interests of their children, and their infant child is now, say, 1.5 years, 2 years, 3 years old, and they both agree this kid is ready to start spending overnights, significant overnights with their other parent, right? And so we're going to start splitting that time more evenly. Maybe we're even getting to a place where we're going to do it equally, right? And both kids are going to be on the same schedule. If the parents have agreed to a change in parenting time, let's say back in January, and you don't file your motion about child support until June, the court can go back to January when the parenting time changed and modify support back to that time. They can also modify it back to a court-ordered change in parenting time. So if the parties go to court over changing the parenting plan. Let's say in my example again that let's say we have a mom and a dad in this case. The mom has the newborn and keeps resisting and saying, I don't want to give up overnights. I don't think dad's ready for overnights. I don't think the baby is ready for overnights. And dad is saying, what are you talking about? We don't even have a baby. Our kid is 3. Our 3-year-old is definitely ready for overnights with me. We need to start moving that way. Mom says no, and they go to court over it. If the court says dad is right, he should have overnights, and I'm going to give him 2 overnights a week going forward, dad can then file a motion to modify child support and have that modification go back to the date when the court order came out saying he gets parenting time. That's about the only ways, though, that you can get it retroactive prior to the date that you file a motion to modify. So like I said, if you have a good basis to do this, you should modify it right away. If you are not sure, which is a legitimate, fair question to ask, talk to a lawyer or run some worksheets on your own. The Colorado Judicial website has resources where you can run a calculation all on your own. You may have to make some educated guesses about what your other your other parent's income is, for example. But if you know we have 2 kids, I know what the parenting time is, I know that we each, I have 60% of the overnights and he has 40, or, she has 28% of the overnights and I have the other 72, then you can run those calculations yourself and get a good guess as to what child support's going to look like. The rule in Colorado is you can only modify if the resulting change is at least 10% different from what it was before. So if the old child support amount was $500 a month, the court won't modify it unless the new number is either 550 or more or 450 or less. If you come to court and definitively prove that now with all the changes you've talked about, child support should be $520 instead of 500, the court will say, I'm sorry, you have to wait until it's at least a 10% change before we'll adjust anything. So running those worksheets is never a bad idea. It gives you some idea whether it's even worth pursuing the change. Another thing that's really important, and this goes back to the idea we talked about earlier, that child support is the right of the child. Having an informal agreement with someone about child support means nothing, has absolutely no effect on reality. So if your child support order says you are supposed to pay $1,000 a month, and you go to your ex and you say, hey, I am in a bind, I can't afford to keep paying $1,000 a month, is it okay if we go to 700? And your ex says, yeah, 700 is great. Let's just do that. I'm sorry about what you're going through because you have the most reasonable ex on the planet, the only one who's willing to agree to these things. If they've agreed to take less money each month, and so you start paying 700 instead of 1,000, that $300 doesn't disappear from your obligation. And so if 6 months later, your ex gets mad at you and says, this is ridiculous, I'm not putting up with this anymore, I want my $300 a month that you've been behind, they are actually legally correct. They get to go back to court and say, you were supposed to be paying 1,000, you only paid 700, and now you owe me 6 months worth of support, which is $1,800. And also, by the way, there's interest tacked onto that because interest accrues on child support as soon as it's due and not paid. That's a bad position to put yourself in. So if the two of you reach an agreement on child support, you must sign that agreement, file it with the court, and ask the court to order it, to enter it as an order. In a lot of cases, the court's going to require you to update your financial information before they sign off on that because they need to know whether what you've just agreed to is what the guideline says or whether it's just some random number the two of you came up with. Remembering again, child support is the right of the child. So the court can't just accept that you both would rather have child support be a certain number. They have to know where that's coming from, and they have to know if it's fair. I should point out something I didn't earlier, which is the court will almost always approve a deviation upward. So if the guideline says that child support is supposed to be 1,000 a month, and you say, I know it's 1,000, but we've agreed that I'm going to pay 1,500, I have never seen a court say no to that. It's the deviations where someone's paying less than the worksheet that the court is going to want to step in on and make sure is fair and is really in the best interest of the child and not just doing a favor to one of the parents. So definitely, if you reach some sort of agreement, put it in writing, get it agreed upon, get the court to sign off on it. All right. One other thing I should mention here, because we didn't spend a lot of time on what is income. The definition of income for child support is incredibly broad in some ways. It basically says income is income from any source. There are some qualifiers, okay? So for example, let's say that you normally work a 40-hour-a-week job and you have a salary and you continue to work that 40-hour-a-week job. But as you're going through a custody battle or a divorce, you take a second job on top of your 40 hours. You're working part-time as a bartender. You're driving Uber. You are doing whatever you can to make ends meet because all of a sudden you're having to pay for an attorney. You're having to pay to move into a new residence. These are expenses you don't normally have, and you're trying to be proactive about not racking up debt, so you take on a second job. The income from that second job is generally not included in your income for purposes of child support. It is almost certainly included in your taxable income to the IRS, but that is not the same thing as income for purposes of child support. Another example of where this can get complicated and kind of fun and why lawyers are sometimes helpful is if you're self-employed. There are plenty of deductions when you're self-employed that make sense for tax purposes and that are completely legitimate with the IRS. Some of those deductions are also legitimate when we're calculating child support, right? It would be pretty insane if, for example, somebody had a business, let's say they have a hardware store, right? And the court calculated income based only on their gross revenue. That would be insane because that's not backing out the cost of the goods sold. It's not backing out the, costs of what they're paying their employees. That's not backing out the cost of owning the physical shop, of electricity, of advertising, of all the things it takes for their hardware shop to even generate money in the first place. So generally speaking, your self-employment income is your gross revenues minus those expenses that are necessary to keep the business running. But some of those expenses that may be legitimate IRS deductions are not deductions for purposes of calculating child support. A good example of that is certain types of depreciation, right? Accelerated depreciation adds back in when you're calculating income for child support. Similarly, if the court looks at it and says, listen, I see how you spent $1,000 a month whining and dining new customers, and you feel like that is a legitimate business expense, and maybe the IRS even agrees, but I think it's too much. And I think really what you're doing is charging your own lunches through your business. So it looks like it's not income. But if you're buying yourself lunch, that is income, and I'm going to add it back in. So the judges have some discretion there to try to figure out what your income is. We could probably spend another hour just talking about what income is for purposes of child support, but understand that in some ways it's more restrictive than what your taxable income is. In other ways, it's broader. So your income for purposes of child support is all defined in that statute that we started the webinar with, 1410-115. It is not the same thing as taxable income. And that is one of the areas where we get a lot of, when we argue about child support, about 90% of the time, it's because we're trying to calculate what everybody's income should be for purposes of the support. All right. We left a little bit of extra time for questions here, partly because we had a lot of them get emailed in beforehand. And we also had at least one get popped up in the Q&A while I was talking. So I'm going to start with some of the ones that were emailed in, and then I'll make sure that I get to the one that was popped in the chat as well. The first question that I had on the list that somebody sent in before we started is there a minimum amount of years before having the child support order reviewed? In other words, I think what they're asking is, if I just got an order from the court last year that said child support would be $500 a month, when am I allowed to go back to court and modify that? The very straightforward and frustrating answer is that it depends on whether there's been a substantial and continuing change of circumstances, and whether that substantial and continuing change of circumstance results in at least a 10% change to the existing order. So if you got an order in December of 2024 and 2 months later, somebody got a new job where their income has doubled, you could file a motion to modify right then, assuming again that that would result in at least a 10% change in child support, which it probably would. In other cases, it may be that 10 years later, child support wouldn't change. So that's a fun one, right? It's not really a time rule. It's based on whether there's been a change of circumstance. On the other side of that, it has to be a substantial and continuing change. So one of the things we noticed during the pandemic, for example, was that, not surprisingly, a lot of people all of a sudden had no income or had substantially reduced income if they were self-employed. And they were filing motions to modify child support, and a lot of courts were saying no, because we didn't know if that was going to continue. We didn't know if their business, if the restaurant that they own taking a hit meant that they were going to have no income ever again, if they were going to have to find a new line of work, or if everything would pick up again in a month, because it was a whole new, crazy, scary time for all of us. So hopefully that answers it a little bit. I hate when I have to tell you that it depends, but it does. The answer to almost every question is going to be it depends, but I'll try to give you at least a little bit of context for what it depends on. Okay, another person had asked about their former spouse wanting to decrease child support payments in another state, and what system is used to decide that, if there, whether there would be a decrease, what paperwork is involved. That's a very specific question, the way it was worded when it was sent into us, and I can't get into the specifics without knowing a whole lot of things. But what I can tell you generally is that we don't let people just move to another state and change child support because they've decided to move. Child support, generally speaking, so once Colorado enters orders about child support, if we wanted any other state to be able to change the child support number, someone would have to file a motion asking that new state to take over the child support case. And the person receiving child support doesn't get to decide what state is in charge. That's always going to track with the person who is paying child support. So if you are the one paying support and you live here in Colorado, and then you stay here, and your former partner moves to Nebraska with your child and then tries to file a motion to modify child support, but you've never worked in Nebraska and you've never lived in Nebraska and you've only ever flown over it on the way to some other state that you wanted to visit. Nebraska is not going to be allowed to decide what child support is unless you agree that that's okay. It gets incredibly complicated when we're talking about these cross-jurisdiction ones because I only practice law here in Colorado. I don't know how any other state calculates child support, but I do know the answer to the question, can the case move to that other state? Right. And so that's part of what's going to happen. The case has to be formally moved because the other thing we don't want is two states being able to modify at the same time. We don't want a situation where Nebraska says, okay, child support's $500 now. And Colorado says, no, I think it's $7. And Nebraska says, all right, we redid the math. We really think it's $4.50. And Colorado says, this is getting ridiculous. I'm going to say 1,000, right? We don't want that nonsense going on. So only one state at a time is allowed to change the child support. And if you're moving your orders from Colorado to another, there's a whole process you have to go through for that to happen. So everybody knows who's in charge. All right. Somebody asked about whether they can get financial assistance if they have temporary guardianship for their granddaughter. The short answer to that one, again, I hate that I keep saying it depends, but it does. There are avenues to receive financial assistance when you are acting as a guardian for a child. And it's not the same thing as child support. It's handled very differently, but it can be done through that guardianship court and often is to help defray some of the costs that you're incurring while you're basically stepping in to take care of someone else's child for a while. It's important to know that because guardianships can often be revoked much more easily than some of these parenting plans can be changed. Sometimes if you start asking for financial support, the parent will push back and say, well, if I'm going to have to pay you, I don't want this guardianship anymore. And things can get really messy and ugly. But yes, there is a way to request some financial assistance if you are acting as a guardian. I had another question, a really good one, about at what age a child's support ends. And specifically, this person had questions about a child with disability. So this is a great question because it also addresses a topic we didn't get to in the presentation itself. In Colorado, if your orders were initially issued here, the age that child support obligations end is 19, not 18. Child support continues until a child is 19, unless that child is still enrolled in high school, in which case the support would continue until the child graduates from high school. So if your kid turns 19 in January, they're in their senior year of high school, they graduate in May, child support would continue until May. If your kid, got held back a couple years and it's going to take them a little extra time to finish, but they are working toward their high school diploma, they're still in school, they're taking classes, child support can go until they're 20 or 21, right? Because it's going to be that age when they have completed high school or when they turn 19. The other exception to child support cutting, I guess there's a couple other exceptions. Child support can end sooner than 19 if the child otherwise emancipates. So if your child joins the military, if they get married, if they go through one of those fun emancipation processes, like we sometimes see child actors do, then child support obligations end when the child emancipates. Child support can also continue past the age of 19 if the child has a disability and a court determines that that disability warrants child support continuing. That is usually for situations where the child is not independent, right? They really do need to continue living at home. And there are countless examples of what that looks like, but it's different than my kid has ADHD and doesn't know what they want to do with their life, right? The fact that they have what is a disability legally does not necessarily mean support will continue. There really does have to be a nexus where the court makes a finding that their disability disables them enough that support should continue. Generally, the way that you do that is you file a motion in the case where child support is an issue, asking that the court extend child support past the age of 19. So that would be the way that you do that. That actually reminds me of one other issue that we forgot to address earlier, which is sometimes people also have the misconception that the amount of child support you receive for having two kids is double what you receive for one kid. That's not how it works. So there are some baseline assumptions that the legislature makes that that it is slightly cheaper or less expensive to take care of two kids than just one. Whether that's true or not is not my problem, right? I'm just relaying to you the way that the law exists and why. And so it actually is not a magic formula. What you have to do is, let's say that you have, in my example from earlier, where we had a newborn and an 8-year-old. At some point, that 8-year-old is going to turn 19, and that newborn is only going to be, what, 11? And so at that time, the court's going to have to do the math and recalculate child support. It doesn't automatically mean if you were paying $1,000 for two kids, you're going to pay $500 for one. I actually had a case many years ago where the parties had 5 children, and somebody came, the person who was paying support came to me and said, hey, 3 of my kids have emancipated. So now we only have 2 kids left that are minors. We went from 5 to 2. I want to modify child support. And I said, okay, your orders are about 8 years old. Let's look at them and run some worksheets before we file a motion and see what this looks like. And when we plugged in the math, several things were important here. One, my client's income had increased pretty significantly during those 8 years. 2, he had stopped paying spousal maintenance. And it used to be that spousal maintenance or alimony was treated as a tax deduction, and it still factors into the child support calculation in some way. So if you're paying maintenance to your spouse on the child support worksheet only, not for tax purposes, but for child support purposes, that amount you're paying in maintenance gets deducted from your income on the child support worksheet and added to the income of the spouse receiving it. So if you're paying $1,000 a month in maintenance, the amount of your income for purposes of child support goes down by $1,000, and the amount of their income for child support purposes goes up by $1,000. So in this case, when he and I ran the numbers, even though he was now only paying support for 2 kids instead of 5, his child support guideline amount would have gone up because of all those other changes. So we obviously did not modify child support. We left it alone and just moved on. All right. Somebody else asked about someone filing in Arizona. The kids were never there. The kids have been living in Colorado with their grandmother. That is a very complicated set of jurisdictional issues, because jurisdiction to decide child support is not necessarily the same as jurisdiction to decide the parenting time. So that is a great example where you probably want to talk with a lawyer and make sure that everything is being done in the right place. If the kids have never lived in Arizona, it's entirely possible that Arizona can't do the parenting time. In fact, really, there's almost no way that they could. But the child support might be here if this is where the person paying support lives. So it gets complicated. To the person who asked that question, please consider talking with an attorney. All right, there was also a question by email about someone who had used the child support services and got child support ordered, but now when they call to get status, they're not getting in for any information, and they haven't received support in about 10 months. Again, this is one where consulting with an attorney, someone could give you a lot better answers to what to do next. But there are basically 2 ways you can go about getting child support either modified or enforced. One of them is just to go to court. The other is to work with the Child Support Enforcement Office. In the Child Support Enforcement Office world, if you and the other party are able to agree on whatever the Child Support Enforcement Office thinks is the right answer to the question, they can draft up a stipulated motion and file that with the court for you and make everything very easy. If you don't agree, though, you will still end up in court with motions and responses and a hearing to decide what the child support should be, if it should change, if it needs to be enforced in some way. One of the tools you can use to enforce child support, if it's not being paid, is an income assignment. That is something child support enforcement can help with. It's also something you can do with or without an attorney in the case yourself. So if you're not getting the help you need from the Child Support Enforcement Office, regardless of whether you've worked with them in the past, you still have the right to go directly to court and take matters into your own hands. All right, that addresses the questions that we had gotten online. We also have a few that popped up in the chat, so I'm going to glance at those here and see what I can do. All right. So there is a question from someone about whether the court would grant more support for child support if the person's income is disability income that's not taxed. So I will tell you that whether the income a parent is receiving is taxed or not does not affect the child support calculations. This is something that my clients inevitably hate the answer to, but child support is calculated based on your gross income, not your taxed or net income. So if you are earning $50,000 a year and after you pay taxes, you're only getting $30,000 a year, $50,000 a year is the income that's used to calculate child support across the board for everybody. It does not matter if you're paying taxes out of it or not. Annual bonuses is a fun question. How are those calculated into child support? This is one where it definitely depends. Generally speaking, variable bonuses like that, commissions, those sorts of things, the court can average them if it makes sense to do that, right? So if one year you get a bonus of $10,000 and the next year it's only 8,000 and then one year it's 15, the court could take those and average them and say 8 plus 10 plus 15 is 33. I'm going to say it's 11,000 a year is your bonus, and I'm going to factor that into the income I use to calculate support. Overtime and shift differentials are really interesting. Overtime is fairly straightforward. If the overtime is mandatory, which it almost never is, even though it feels like it, okay? So I don't mean mandatory like my boss will hate me. I mean mandatory like truly your employment contract says, and by the way, we can force you to work overtime when necessary. That is sometimes true for nurses, not always. But there are some circumstances where, people in particular positions can't leave if they don't have a replacement, right? Situations like that. So bottom line is, if the overtime is truly mandatory, it can be included in your income. But if it's voluntary, it's in that same category like the second job. And the court will not consider the overtime if it's voluntary. They'll only look at what your regular pay is. Shift differentials get much more complicated, and that's something that if you're dealing with them, you should probably talk with an attorney about. But yeah, again, it's sort of generally the fact that you're getting paid more because it's a holiday, for example, is not going, it's still going to be counted as part of your income for support purposes. All right. If you have an existing, so this person said, what if I have a court order and the child support division lowered it? If you went to child support enforcement and asked them to modify, or the other side asked to modify, and they came back with a recommendation that said, based on our calculations, we think support should be lower than it was. If everybody agrees to that, they will file that with the court and it will become the new order. If one of you says, hold on, I don't think it should be lower, then you have the right to go to court and fight about it. Child support enforcement will present their position. You can put on your evidence. The other parent gets to put on their evidence, and the court will come up with an answer. So this one is a slightly longer question, but it is an important one. This one asks, what if the parenting plan says that a parent is supposed to have 3 overnights a week, but they're not exercising those, and this kid hasn't actually spent a night at their parents' house in a very long time? That is a situation where sometimes you can use the retroactive modification. If you can show that both parents agreed the overnights were going to stop, you can sometimes go backward. If it's a situation, however, where the parent wants to have those overnights, but someone is just blocking them or not making it happen or coming up with excuses, the court is likely going to use the amount of parenting time that's happening on paper that's supposed to be happening and not the time that you would have. So that's one where it depends is in big, bold letters, and you should definitely talk with an attorney about what that's going to look like. All right, we had another question about what if one of the parents loses a job? And so there's the question this person actually asked, which I will address, and then a secondary question that I want to get to. So the question they actually asked is, what if my ex loses a job but has been paying the support without issue even while they're unemployed? Probably they're either cutting into their savings, or they're using, if they got some sort of a settlement package as part of being laid off, they may be using that income. If they're still meeting the support payments and they reasonably expect that they're going to be able to get a new job at a similar amount, that's all fine, right? And technically, losing your job doesn't excuse you from an obligation to pay child support or spousal support. So this person sounds like they're doing what they're supposed to be, which is doing their best to meet their obligations. If that goes on for 6 or 7 or 8 months and they think, I have been shaking every tree and I cannot find a new job, they would be in a position to say, you know what, now this feels like a continuing and ongoing issue. Sorry, a substantial and ongoing change. And I'm going to need to revisit child support because I've been trying to find a job for 9 months and haven't been able to. There is a calculator. It's on the Colorado Judicial Court website. So that is, if you Google Colorado court forms, for example, you will find the judicial website. And on there are a bunch of forms that include the child support calculator that you can use to try to come up with what those numbers look like. You can also, reach out to an attorney and try to get a meet and greet with one of them, to kind of run some rough numbers and see what things look like. One of the things that Kathy may well be prepared to tell you all in a minute here, but I'll jump the gun and jump it in, is that we are always happy to take consults to meet with you all and give you some idea of whether you have a case, whether there's anything we can help you with. Because you have attended this webinar tonight, you get a discount you actually get that consult for free with one of our intake attorneys. So if you're having these questions on your own, please reach out to either our firm or a lawyer at another firm and try to get some better guidance about your actual situation. All right, let's see. Last question, and then I'm going to let you all go because we're just about at 6 o'clock here, is whether car insurance for a child who has their license is considered a part of child support. It is not. There's not a line item on the support worksheet for car insurance. This is one of those interesting areas where technically you don't have to let your kid get a license and you don't have to insure them. You don't have to let them drive. They are still a minor. If you want to tell that 16-year-old, I don't care that you're 16. I am not going to pay for you to drive. I'm not going to pay for you to have a car. I'm not going to pay for you to take the class. I'm not going to do I'm not going to invest the time so that you can become qualified to drive. Because all of those things are true, you the insurance itself will not go into the child support. Also, often what we find is that parents will want to cover them on their independent policies, right? The parents don't have a shared vehicle insurance policy anymore. So sometimes they're trying to cover the kids on both ends of that. And because of that, it may be that you're each paying insurance. So the short answer on that one is no. That's one where it doesn't even really depend. About the only place it would depend is if the parents agreed to include it. But if not, the statute does not include that in the worksheet. So, all right, I have gotten us right up to 6 o'clock. I think I got to almost all of the questions. If there's a question that you had that either I didn't get to or you did not raise your hand to ask, please, like I said before, feel free to reach out to us, schedule a consult, and one of our intake attorneys can get you a better answer than I can on the fly during our little webinar here. So thank you all again for attending. Kathy, anything else you need to tell these folks before we sign them off?
I don't. You stole all the words right out of my mouth. So if anyone does have any questions, just call our offices at 303-622-5502 and we'll try to help you in any way we can.
All right. Thanks, everybody. Have a wonderful night and good luck with whatever it is that you're going through right now.